What's up, everyone? Hello, Amanda. Wait till we get a few more people in here. Close down a few of these chat threads. All right. So tonight we are going to discuss a few things, but mostly 18 U.S.C. 241 and 242, often quoted. What's up there, John? 1 second here. Get this stylus feel out. I'm doing all right. How you doing, John? It's warming up here. Today was kind of wet and rainy out, chilly. It's supposed to be kind of that way tomorrow. Seymour, how are you? Yeah, I'm doing well, very well. Short show tonight, but as always, I try to provide you with a little bit of stuff every Friday. So, there are some links in the description. I'll be referring to some of these articles, a few things here. Anyway, first and foremost, thank you to my mods. Thank you to anyone who sits through and lets the ad play so I can get my I've done the math. It's like, I don't know, 0.1 cent maybe per ad view. So if like 500 of you watch a video, I think I got like 50 cents or 60 cents, something like that. So thank you for the folks that let the random ads play. I've let YouTube do or Google advertise all kinds of fun stuff. I see, I've watched some of the ads occasionally when I'm checking my videos for details and stuff while I'm writing about things that have happened. And I see a very random assortment of ads that play. So there doesn't seem to be a general theme based upon who views my ads. It's a random assortment of stuff. Some of it's new to me. I've been watching stuff on YouTube for a while, but based upon the hoops that you have to jump through to play ads on your YouTube channel, it was very surprising, some of the ads I've seen. I believe the first one was referencing like men's body hair manicuring. I believe they said the word balls about 12 to 13 times in this ad. It's the first one I've seen them play. But they have quite an extensive list of rules and things like that will demonetize you. I have a lot of videos that are not eligible for monetization because I curse too often. The F-bomb will pretty much kill any sort of monetization. I've seen. It's pretty interesting to watch the analytics and how things all work. It's not financially conducive yet to make videos, so that's an interesting little thing to watch. Basically, kind of a hobby. This sort of the ads cover, an SD card here and there. So I was interested to see how it would all work out. Like I said, I'm all about transparency. I don't mind talking about the monetization of my channel. I think it's something you should be open to once you monetize and everything. So anyway, I never watch the sport monetized channels. I support, allow them to play volume off. I mean, hey, appreciate it either way. A couple cents here and there adds up to 10, $20. That's an SD card for a camera or something else. Anyway, so let's get to this. I've got a little bit of stuff I'm going to talk about here. Like I said, it'll be a relatively short show, probably one of the shorter Friday nights we've done. It's late, I'm tired, got to get up early and go have some fun doing some stuff. So, anyway, let's get to it. I chose tonight's topic because I noticed that today, South Bend Mayor Pete Buttigieg was in the New York Times. There's an article in the description there. It's six down, and basically questioning his previous firing of a black police chief when he first came into office in 2012. Basically questioning his motives. Was he persuaded by several racist white police officers who were under fire at the time to fire the black chief of police, up and coming young white Democrat, so this is basically the topic in the article. It got me thinking about basically previously one of my Friday night sites. I discussed the Elkhart, Indiana detective long lost records surface wrongful conviction case fondling informants from ProPublica article. And it's basically Keith Cooper and Christopher Parrish were wrongfully convicted. A lot of these records that would have proved their innocence were kept hidden since about 1997. Keith Cooper is Indiana's first pardon based upon innocence. He received that in 2017. Long story short, this cop was having sex with informants and convincing them to lie and get people wrongfully imprisoned. So this dude Keith Cooper and Christopher Parrish, they did a bunch of time for these robberies that they didn't actually commit. They were imprisoned, at the testimony of this officer who was coercing his informants. And there's this big debacle in Elkhart County about the records, and ProPublica as well as South Bend Tribune. I believe it's Kristen Scheckler is the journalist that was covering all this. Anyway, they were covering all of this, so they got me looking into it, and one of the things that I noticed was that what would it be? January 12th of 2018, Mario Guerrero Ledesma, he's in a video where he's handcuffed, he's in a chair, I believe strapped to this chair, and basically there's 4 police officers from Elkhart, Indiana Police Department, I believe. 2 of them, Corey Newland and Josh Cites, basically start just punching this dude, and they claim it's over him spitting. And anyway, there's the last article, justice.gov, basically has a link to the indictment for these 2 gentlemen under 18 United States Code 242, deprivation of rights under color of law. Says 18 U.S.C. 242, deprivation of rights under color of law. Whoever under color of any law, statute, ordinance, regulation, or custom willfully subjects any inhabitant of any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such inhabitant being an alien, or by reason of his color or race, than are prescribed for the punishment of citizens, shall be fined not more than $1,000, or imprisoned not more than 1 year, or both, and if bodily injury results, shall be fined under this title, or imprisoned not more than 10 years, or both, and if death results, shall be subject to imprisonment for any term of years or for life. Now, their indictment specifically says, background: on January 12th, 2018, defendants Corey Newland and Joshua Titus were on duty as police officers with the city of Elkhart when an arrestee, ML, that would be Mario Ledesma, was brought into the police department's booking area. Officers placed Mario Ledesma in a chair with his hands handcuffed behind his back and behind the back of the chair. Count 1. On or about January 12th, 2018, in the Northern District of Indiana, the defendants, the two police officers, the defendants, Corey Newland and Joshua Titus, while aiding and abetting one another and while acting under color of law, willfully deprived arrestee, ML, of the right secured and protected by the Constitution and the laws of the United States to be free from unreasonable seizure, which includes the right to be free from unreasonable force by a law enforcement officer, specifically when ML, still handcuffed in the chair, spat in the direction of defendant Newland. Defendants Newland and Titus struck ML in the face, causing him to fall backwards onto the floor, and then continued to strike ML repeatedly. The offense resulted in bodily injury to ML in violation of Title 18 United States Code, Sections 242 and 2. 1 second. What is Section 2? Aiding and abetting each other. It's an interesting. Whoever commits an offense against the United States or aids, abets, counsels, commands, induces, or procures its commission is punishable as a principal. Whoever willfully causes an act to be done, which if directly performed by him or another would be an offense against the United States, is punishable as a principal. Anyway. Not as important. Not for this show. Anyway. So, what are we talking about here? We're talking about a unicorn. By the way, this is filed March 21st, 2019. Cause number 219 CR0023. It's in the United States District Court for the Northern District of Indiana, Hammond Division, United States of America, v. Newland and Joshua Titus. Like I said, there is a link to this indictment. In the link, you will notice the Attorney General for the state of Indiana, Thomas Kirsch. K or H. Kirsch, yeah. Speaking on this, he says, my office takes allegations of civil rights violations seriously, including use of excessive force by police officers sworn to uphold the law, said U.S. Attorney Thomas L. Kirsch. Maintaining integrity in the criminal justice system by investigating and prosecuting police officers who step out of bounds with the law while working with, training, and promoting good relationships with law enforcement who operate within the law are important functions of my office. Today's indictments send a clear message that the FBI won't tolerate the abuse of power or victimization of citizens by anyone in law enforcement, said Grant Mendenhall, special agent in charge of the FBI's Indianapolis division. The alleged actions by these individuals went against everything in the oath they took to serve and protect. This charge carries a maximum penalty of 10 years imprisonment and a $250,000 fine for both defendants. An indictment is merely an accusation, and the defendants are presumed innocent unless proven guilty. Fuck that. Guilt. Video doesn't lie. They definitely punched this dude in the face. They wouldn't be speaking on it in this tone. They wouldn't have indicted them. They know that the video damns these two officers. There's 4 officers in the video. They should have indicted the other 2 for 241 conspiracy against rights. If 2 or more persons conspire to injure, oppress, threaten, or intimidate. Anyway, they or some sort of hiding a felony, something of that nature. Their inability to act. A attorney should pursue a failure to train theory, indeed, because the good cops certainly didn't intervene anywhere in this video. It's this video is pretty tragic. Like another video that I recently watched, a Julian Pagel, I believe, Paegle. This would be in Marion, Indiana, Saturday, April 6th, around 2:30 p.m. An officer, Billy Cole, and an officer, Griffin, basically were serving a warrant for failure to appear and escape the 800 block of East 26th Street, Marion, Indiana. That's Grant County, Indiana. Long story short, these officers handcuffed this individual. He's cuffed, he's on the ground, he's apparently kicking them, and the one of the officers ends up kicking this gentleman, Julian, several times. In the report specifically, he says, quote, he delivered 2 kicks to Mr. Pagel's back. After delivering those kicks, he stopped physically resisting. All the articles I could find about this incident sort of reflect the same narrative. One, they speak with an Indiana State Police officer where he states that police officers are trained to use like force against like force, fight fire with fire. So he was kicking, basically, and that's why the officer kicked him back, because he was kicking. But the officer wasn't in handcuffs, so that makes quite a difference. Individual is considered restrained, or at least partially restrained, in handcuffs. What's up there, Regina? So then the report flat out says, he kicks him. The video shows it. they did have a warrant for this individual's arrest for failure to appear and escape. This was actually the address that he was located at, was listed as the warrant, but kicking someone while they're handcuffed and laying on the ground is called excessive force. And well, I believe we just read that they willfully deprived the arrestee of the right secured and protected by the Constitution and the laws of the United States to be free from unreasonable seizure, which includes the right to be free from unreasonable force by a law enforcement officer. Now, this individual had been arrested or had been transported to the jail. Okay, no one's claiming that he was unlawfully arrested. They're calling his unreasonable seizure unreasonable. His seizure was unreasonable because it was not free from unreasonable force by a law enforcement officer. What's up there, James? Now, this is important because there's varying degrees of what's considered to be a seizure. As you may know, if you watch my channel, I reiterate this all the time. The words used in legal situations, legal definitions, legal words often have many definitions. This is why there's a law dictionary, several of them, in fact. And one of the reasons for this is because the varying ways that words are used, period, in the English language to define things. I think it's Chinese. They have like 6 different words for love. You love cereal, you love cat, you love your wife. Different words for different love. English isn't like that. We have one word with multiple definitions. So to be free from unreasonable seizure, there's a reasonable and unreasonable seizure. Even if your arrest is legitimate, even if you were guilty, you can still be the victim of excessive force, which is a deprivation of rights. Clearly, because we have the United States Attorney Thomas L. Kirsch explaining in plain English to you that it is. Now, why is this important? Because this is the criminal equivalent of the civil remedy known as a 1983 suit. A 1983 civil lawsuit is a civil remedy to a civil rights violation. 241 and 242 provide criminal remedies, criminal prosecution, as opposed to civil prosecution, which is an entirely different thing. As you see, as opposed to some sort of potential payout to, of an insurance claim, or something of that nature. What's up there, Jeff? This is police officers facing criminal convictions and time. The terminology is 10 years, fines of $250,000, things of that nature. That's the same penalties and punishments, fines and things of that nature that one would be facing, say, for possession of a firearm in violation of the Patriot Act, 922G1 specifically, 922G2, 922G3, 922G4. This is a pretty big deal, and it's close to home, so I found it very interesting. Didn't get much press, but this is directly from the Department of Justice. It's a press release from March 22nd, 2019. But as I said, you can look through the articles where they're posting about this one in Marion, Indiana, the guy that was kicked several times, Julian Pagel, while he was on the ground. There's several attempts to sort of mitigate the officer's behavior and, sort of justify this in the press. That's typical. It's very normal. A lot of people try to do this. But this is excessive. It's also unreasonable. Things of this nature happen, and one of the reasons that the press attempts to sway the public's opinion is so that something like this doesn't happen, because this is a real possibility. And the more you see if something happens close to home, hopefully it doesn't. If something happens in your area like this, you'll notice a lot of the times, the more your local press covers it in a fashion like this, to where they sort of try to mitigate the officer's behavior and justify any sort of excessive force, it's so that any sort of potential civil repercussions later, the public, there's sort of what they will remember is what they wanted to be remembered. You know what I mean? So what they'll take in this propaganda bullshit, and they'll later regurgitate it to themselves, should they be subject to, sit on a civil jury that decides, whether someone should be, given essentially a lawsuit payout for civil rights violations or something of this nature. You never really know who they're going to pick from the public. So the media is very essential in helping with the narrative that police officers are justified in using any force whatsoever for any reason at all, and for any ridiculous reason at all. Fight fire with fire. He was in handcuffs, he kicked me, so I started kicking him in the spine. Anyway, so I'm gonna check this chat out real quick. I've been going on rambling for a little bit here, so oh, Don. Yes, I am. I am still planning to run for office next year. I will be running for a LaPorte County Soil and Water Conservation District Supervisor role. Help protect natural resources, watershed locally, things of this nature. This is a volunteer position, essentially. I believe they used to get a per diem to cover, expenses, specific expenses that they incurred, but I'm pretty sure they've done away with that at this point. Things of this nature usually don't have the bigger funding. Right now, I'm actually a non-elected position. I'm an associate supervisor for the LaPorte County Soil and Water Conservation District. It's one of the reasons why I'm taking this. It's a pilot program. It's the Indiana Master Watershed Program. Typically, people hear of your Master Gardener program. There's several others. For instance, right now I'm taking this Indiana Master Watershed Program. I'm a master recycler. Next, I'm probably going to go for, I believe there's a master naturalist and master gardener. However, probably before the master naturalist, I'm thinking about trying to go for a certified birder, a birder certification. There's 3 levels essentially, so I'm trying to at least do the first one and get started on this. So, like I said, but yeah, I will definitely be running for office again next year. There will be another position open, um, and I will be running for that. So, like I said, do a little bit more than ask for public records, ask for a lot of public records, not just about police accountability and local governmental agencies, things of that nature. I'm very interested in some of the we have a big brownfield Superfund site going on that's being remediated and bought and sold and things of this nature. It's I think they've got something like $8 million poured into it, and not anywhere close to being this big, probably borderline gentrification kind of condos that they're going to do for a bunch of people that aren't from here to move into and live in some sort of gated community kind of thing. There's a lot of different ways a lot of this stuff ties into each other, to be honest. The lack of concern for a lot of environmental stuff and natural resources, which if you've watched my channel long enough, you understand that there are a lot of wonderful natural resources and environmental things to be concerned with here in LaPorte, Indiana. We have 7 lakes and I believe 18 parks, 19 parks, 18 parks. It's very unique. The diversity of the different kinds of land that we have here. There's like a residential business district, but there's parks and lakes all over the place, spread amongst everything. It's a pretty unique place. So I believe somebody commented that, yeah, getting involved is key. It is, yeah. It's kind of what I'm all about. Getting involved is key. A lot of these decisions are made the correct way legally. Things like this happen because the people that live there in that community don't pay enough attention to what their representatives downtown are doing. I file public records requests and I do public notice audits, as I've termed them, to I go and see what sort of public information has been posted, where it's posted, how visible it is, how many different areas information is posted, just to sort of see how easy it is for an individual to readily learn about what's going on in their local government if they walk into City Hall. The old expression, people eat with their eyes, where you hang something up, where you take this piece of paper where you put information on it that's public notice, information that you as a public agency are providing to the public, where you take this information and hang it up, that matters. Because if you hang it up somewhere where you know that someone's not going to see it, I believe that's intentional. I believe it's deceptive. I believe if you didn't know any better, then you're negligent and ignorant, and you shouldn't be in that position or have that responsibility doled out to you. But it's one of the reasons why I try to encourage people to do public records requests and to attend public meetings, because a lot of things are done in the name of the public without the public's awareness. and the public has a say. So there's like, for instance, your local like a redevelopment commission here in Indiana. You know, locally, most towns, counties, things like this, they have a planning commission, economic development commission, redevelopment commission, things of this nature. All of these are public agencies subjective to the open door law of Indiana, as well as the public records laws of Indiana, which is in state's version of the federal FOIA Act. And the redevelopment commission has annual reports. They have opportunity for public comment. Their meetings are supposed to be open to the public. Locally, ours has a lot of executive sessions which close information off to the public, where they discuss real estate. An individual who, well, very heavily involved, and possibly owner, don't want to say that specifically, but same last name, and definitely heavily involved in the construction company that gets a lot of city work. He's on this redevelopment commission. He's discussing private matters such as real estate. Things like this happen because people don't attend these public meetings. People don't request the meeting minutes. And essentially, you have so much time to challenge, which an individual can appeal or challenge these decisions made by their representatives. It's called, for instance, with the redevelopment commission, it's called remonstrance. And you have so much time to get a petition, signatures, file paperwork, things of this nature, to sort of remonstrate, challenge, this decision made by a board or a commission or whatever, to have a legal standing. If you don't challenge it in the right amount of time, you've not timely filed, and it can be dismissed. So if the public's paying attention and they're aware of what the process is, they can challenge legally in a courtroom here in Indiana. The citizens could legally challenge the decisions made by the representatives, instead of just taking it on the chin and saying, I'll vote them out next time, because that's the typical process that I see myself. Anyway, went on a little philosophical tangent there. Let's yep, there's the clock. What are we at? It's still off. Yep. So run for sheriff. Hell no, I'm not running for sheriff. The coroner is the only person that can arrest the sheriff. So let's say hypothetically I ran for sheriff. Locally, we're not really good at picking coroners. Like, we've had one indicted for one prosecuted, convicted, I'm pretty sure, for selling pain pills. We've had another one recently that he's charged with breaking into people's homes and rifling through their things. I remember the article made it seem like he was going through women's clothing, some of their private articles of clothing, after he broke into their house. So yeah, we tend to vote a bunch of criminals into office for coroner here. I ain't trying to have that be the only guy or only individual that can arrest me if I'm sheriff. And I can't be sheriff because I haven't gotten all my expungement paperwork, finalized yet. So got a little bit of a record that would prevent me from being sheriff. Anyway, but yeah, the language in this indictment, I was actually really surprised. I believe one of these officers, getting back to this, I believe one of these officers was related to the chief of police or the assistant chief of police or something of that nature. So I was actually, I'm really surprised to see this, but this is a beautiful thing. Like I said, the attorney general's, he's making some strong claims. He's claiming that there is a line that he has drawn, and that officers that are found to be on this side of it will be prosecuted. Will not tolerate the abuse of power or victimization of citizens by anyone in law enforcement. That's some strong language, very strong language. The indictment, though, is very simple language. Very, very simple language. Free from unreasonable force by a law enforcement officer. The right to be free from illegal search and seizure also keeps you free from unreasonable force. So, it's something to think about when you're, if you're thinking about your options, should something happen to you. I'm often told to contact the FBI myself. I may give that a whirl. Stay tuned. You never know what might happen on this channel. Yeah, be an interesting phone call indeed. So, a few updates. One of the things that got me thinking on this is, I'm a hybrid. I have a hybrid counsel. Essentially, been appointed a public defender, and I'm sort of pro se, and we're going to work together, and we're going to do this trial thing here in June, I believe, June 17th, I believe. That's what's going on with my 3 current open criminal cases. One for criminal trespass / resisting law enforcement. One for a battery for an individual who tried to take my phone here. And one for intimidation on the city attorney. Long story short, the intimidation is bogus because as of State v. Brewington, a 2014 case, intimidation has been clearly defined as, either a threat to an individual's safety or a threat to an individual's reputation. One is potentially, possibly, maybe, if you can prove it, a civil cause. The other one is definitively a criminal thing. Claiming that you're going to damage someone's reputation is not a criminal matter. So the intimidation, I'm not really worried about at all. It's clearly not intimidation. The battery is clearly self-defense. Nobody wants to set the precedent that you can just walk around in downtown LaPorte. What's up there, Terry? Nobody wants to set the precedent that you can just walk around downtown LaPorte and take phones, because that would make it legal to just walk around downtown and take people's phones. I like to operate within the confines of the law myself. So if that all of a sudden became legal, I could make a good bit of money selling used phones, especially if I didn't have any sort of cost to procure them. So I don't anticipate that that's going to sort of override the obvious self-defense there. Moving along, what's left, which is likely I did not record any of this I didn't even make notes. Basically, the attorney was somewhat apprehensive. He did not want to be recorded. He is aware that the head of the public defender's office has a video on my channel. He did not want to be subjected to being in a video that is online. So tisk tisk, Chris, no recording. Anyway, he's basically telling me he anticipates the only thing that may be a problem is he thinks this special prosecutor that I've been appointed might want to argue the resisting law enforcement a little bit. I anticipate that's because there's a attached criminal trespass that the resisting law enforcement sort of hinges upon. I'm arguing that I'm on public property with a court order for public records from a local judge, and I can't possibly be trespassing because I'm a citizen. And, you know, I bottom line lay it out that the mayor is essentially there with my permission. I am the principal. I have given the mayor agency through voting. The mayor of the city of LaPorte of Indiana is not trespassing because I have given him permission to be on the property. Essentially, this is how voting works. You take an individual and you give them permission to be in that office. I lay this out as simple as it is. It's public property held in the public trust. I am the public. So then there's the resisting law enforcement, which if I'm not resisting law enforcement because there's no law being enforced, I am what? I'm being subjected to unreasonable force by a law enforcement officer, which is a violation of my civil rights. What does that do? That subjects these officers to criminal liability, and it subjects the city of LaPorte to civil liability. Not surprised this is the one that they may choose to not immediately dismiss or whatever. This may be the one they take to trial because this one has an actual fallout. From what I can tell in Indiana, nobody's argued the public property / trespassing thing out while they're in City Hall with a court order for public records. So could go to trial. They could count on the average citizen's ignorance and naivety, going about their daily lives and never interacting with the justice system. Essentially, that's what a jury usually is. A bunch of people who don't know anything about the law, rightfully so, because they've never interacted with it. That's why felons can't be on juries, because they know what's going on. But this may be the only one that they try in front of a jury. They may be able to convince themselves that they're going to be able to deliver this speech that I'm trespassing. But like I said, this is a hybrid situation between me and the attorney. He claims he's going to, he wants to go to trial, and then he's coming up with these tactics and theories and plans already. But I also have my right to speak, so I don't know if going in front of a jury is the best option for a prosecutor's office to try to argue. These people that are not any different than me can be removed, because I'll explain what the prosecutor is saying to them in plain English. This dude's saying, fuck your right to be in this building right now, that you can basically go to jail for it, or your taxes pay for these buildings, and your votes put these people here in charge of the money that maintains them and the roads and all these things, because this is America and it works the way you think it do, and you're able to use this power that you've been given as a citizen. You know, like I said, trial's not going to go the way they think it's going to go. But that might be the one they actually try to take to a trial. But other than that, not much really going on with any of my cases, other than the appointment of the special public defender and the appointment of the appointment of the special prosecutor and the appointment of this new public defender, and the judge being willing to let me, you know, do this hybrid thing, to where I'm pro se with this standby counsel for a trial that will be coming up, like I said, in June. But anyway, I'm getting tired. It's been a long day. I gotta get up in like 6 hours, so I'm gonna go ahead and let you guys go. Thank you everyone for showing up. Intended to be actually a shorter show. Thank you, Seymour. Thank you everyone for showing up. Like I said, I'm tired. I'm getting a little loopy here, so I'm gonna go. Thanks for watching. Like I said, know your rights, know exactly what they are, know when and where they apply and to what extent. What's up, though? What's up there, Huckleberry? You know, even, man, I'm gonna do a show on a myth versus fact soon. No. All right, though. I'm out of here. You guys take it.